Hello and welcome to another video. I'm Simon Varley, Director of Digital Forensics with Purpose Legal. Today I'm going to be talking a little bit about the role of a digital forensic examiner in criminal defense work. One of the first things they have to do, and one of the primary roles in explaining the evidence set against, a defense attorney's client. Help them discern how to build their case and understand the digital evidence that is going to be put forth by the opposing side. So we do this by, I do this by this technique called the chain of suspicion. A cheesy title, I know, but I haven't come up with a suitable replacement for that name. But it is basically a way of visualizing and summing up a bunch of, discovery produced documents, forensic reports and things like that, and summing up in a way that an attorney can understand and highlight potential weaknesses in the case and where to focus your efforts. Feel free, if you're seeing this on LinkedIn, feel free to put in the comments, if you have any questions or nice comments are always welcome. If, shouting you're an idiot is, from the back of the theater, that's also welcome. All comments are welcome. I think of all the industries out there, I don't think digital forensic people are very open about discussing methods and techniques. And I think it's the only way we actually learn, apart from doing it ourselves and learning the hard way. But if we can share a bit of knowledge, I'm big advocate for that a rising tide lifts all ships, sharing techniques, different things only helps the industry as a whole. So feel free to post any comments, but we're going to be going through what it is, the chain of suspicion. We'll go through a very general example and then one based on a case I worked that highlights the importance of doing it, however futile it seems at the start. So, okay, well, let's dig in. Okay, let's talk a little bit about this chain of suspicion. What is it exactly? Well, it's a way of reviewing discovery documents, law enforcement forensic reports, and laying out to the attorney exactly how the law enforcement came to knock on their client's door. So it's a good way to visualize it, and its use might become apparent once we go through this. I'm going to show a standard example now, and then I'm going to do a little one based on a case I worked and why that will show more the importance of it. But let's go through this one first. So this is an example. Basically, the important part of it relates to a visit to a website, whether it's a website with bad content or it's, charges based on a insightful post or something like that. But the evidence coming from a website that law enforcement has been investigating. So that's our example. So what happens is we've got this website that's known, could be a source of the charges. Law enforcement will contact, in this example, in the documents we'll say, law enforcement contacted the website or its hosting provider and requested a list of either visitor IP addresses or the poster's IP address that he set up the account. Now, a IP address is essentially an address that gets used for when a device accesses the internet. It's an identifier. They're not unique to people. If you look up an IP address, it's not going to give your name and address anymore. Now most of them they're bought up and registered by internet service providers and handed out upon a request to a subscriber, someone using. So if you use AT&T, Verizon, all these companies, when you try and connect to the internet, you'll be allocated an IP address that gets registered by websites when you're browsing. So law enforcement will have got the IP address of interest. They would have looked it up online. There's lots of different places that can look up IP addresses that are available in Google. and you'll get back a response. It'll be something like, in this case, AT&T. So they worked out that the IP address was an AT&T user. So they will have reached out to AT&T for the subscriber info and said, who used this IP address on this date and time? And that's important to have the date and time as well, so that you know who's using it, because it could be someone different. They could be allocated to someone else at a different day. So if you provide that information to AT&T, they'll get back with you to say, here's the subscriber info, Mr. and Mrs. Smith of this address. It's there in this account number. That's the account that used that IP address on that day. Now that can be quite damning, especially if it's Mr. and Mrs. defendant. That's obviously quite damning. But that just gets us down to the Wi-Fi router. At this point, anybody using their home Wi-Fi to access that site would have left the exact same evidence. So obviously there's other steps that are normally taken, maybe enough to get a search warrant, but a lot of times when these documents for search warrant was exercised, then we'd see what was found there. That would be in discovery. And they would normally say, oh, well, we found this laptop. And then further evidence on there that they might have found, basically, that they think was used to access this site. So they'll have the device itself. And then the last step is actually to put the defendant in front of that computer. That can be anything from it was password protected to, well, in one case that I worked, somebody actually went to a bad website and 30 minutes earlier was doing their taxes. So they'd logged into H&R Block. And so that was obviously quite definitive with all the security and everything to go through that it was the defendant in that case that had used the computer at that time. So this is the chain that will be presented across a lot of documents in discovery, a lot of processes, and it might not be obvious to the attorneys or public defenders exactly what it means, all of this IP addresses, and they might, without doing this process and laying it out like this, it's kind of a roadmap of what they did. They might not be aware of what to challenge. And that's the purpose of this. If what shouldn't they waste their time on, right? Obviously, in this case, it's quite, definitive and straightforward in the steps they made. There's no point challenging AT&T saying they got the wrong subscriber, etc. But where do you focus your efforts? But obviously, it isn't always as laid out as this shows. So we'll go on to a specific example, and then I'll show you what was actually received and why it's important to do this. Okay, so in this example from my old case, the evidence against the defendant, the start of this chain was from a chat app called Kik, K-I-K. And so that's where law enforcement started. And so we built up kind of multiple chains here, but they basically went to Kik. There was an account set up, and they contacted Kik, and they wanted first of all, they got the IP address that connected to, was owned by AT&T. So then they went to AT&T and said, here's the IP address, here's the day and time of these communications, who's the subscriber that used that IP address. And it was the account of Mr. and Mrs. Defendant. They then went to Kik and said, okay, what was the email address used to sign up for this Kik account? Well, it was a Yahoo email address. So they went to Yahoo and said, what's the IP address of the person that last logged into this Yahoo email? And it belonged to Verizon. So they went to Verizon and said, which of your subscribers was using this IP address on this day and time? And they said, it's a family plan for Mr. and Mrs. Defendant. And then they had one other avenue as well, one more chain, because there were images and videos on the chats that were in Kik, and the person in the video closely resembled Mr. Defendant, and he was wearing a quite prominently featured hoodie, dark, with white lettering on it, or light lettering, that was an acronym for a university that matched something that the defendant owned. So as you can see, with these three different chains and how it would look in discovery across a massive amount of paperwork, it seems extremely definitive, you know, and I'm sure everyone's thinking, well, you know, done and dusted. And so, you know, that's certainly the way it seemed to the public defender, who got the case quite late and was looking through this and going, oh my goodness, where do I even start with this? So this is the purpose. Even though it looks futile, let's go through the purpose of the chain and see what's missing. And obviously we can see here where the chains stop, and that we don't actually have any devices currently that were identified in discovery. They don't have a device that was used, and they don't have an actual person there that they've identified positively, other than, you know, obviously the images and the video and the likeness there. But these, you know, let's just document that, however futile you think it is. Let's just document that those connections weren't there. And now in the discovery, in the reports, it seems very comprehensive. The way it's worded, you know, quid pro quo, he did it. But then we move on to something, you know, we start to dig. First of all, when you look at that, it's obvious when you lay it out like this, where the efforts of the public defender should go. You know, where are the perceived weaknesses in the case? It's obviously about the devices and the people there. They're not there. You know, when I say perceived weaknesses, because maybe there is something that wasn't disclosed in discovery, that maybe they collected other devices or whatever, but didn't feel the need to pursue it because of the overwhelming evidence or whatever. But, you know, it's obvious from a layout like this where the effort should go in challenging this case, to the right-hand side of this. And that was what I recommended. And, you know, from there, you know, it takes a very interesting turn. So from there, because we were focusing on the actual devices and the people, we look back into the discovery disclosures. And what we see is there's a lot of photographs and details about the execution of the search warrant that happened at Mr. Defendant's home. Based on all the other evidence, they got a search warrant, they went in there, they captured Mr. Defendant's computer, cell phone, exactly. And since there was nothing disclosed, you know, it's safe to assume that nothing was actually found on there, which, again, doesn't mean it didn't happen on any devices. But one thing we noticed, because we were focusing on this and this little weakness, was that during the execution of the search warrant, there were about 7 other males in the house at that time. It might have just been a one-off when they executed it. It might have been having a party, who knows. But there were recorded 7 other people, and obviously, you know, 12 other devices in there, iPads, iPhones, that were not collected or were not disclosed as being reviewed in there. So that's obviously something to look at in there. And it's important to know, as we discussed before, from what they have, apart from the image that was from Kik with, you know, that has the likeness of the defendant and the clothing, you know, that we'll come to that in a minute. With the Yahoo Mail, the other 2 chains, it stops at the house. You know, other people could have been involved in that. And, you know, well, first of all, the first chain with AT&T, you know, anybody in that house connecting to their Wi-Fi on their device would leave the same evidence there. So that one is quite questionable. The Verizon plan one is a little bit more difficult to deal with, and obviously the images too. So we start looking at there. Then we discover, based on this, who was there, documenting who was there during the execution of the search warrant, and other documentation that the Mr. Defendant has a brother. Now, the brother was staying with them during this whole time, and during the time with the alleged connection to Kick. He was there, and he closely resembles Mr. Defendant. They were not identical twins by any means, but in build, hair, in quite a lot of ways, they look very similar. And then we start to look at, obviously, the video with the likeness and the hoodie that was a dark color with the letters of the university. The brother got the same hoodie, but in black, and the defendant got one in dark blue, and the black one was faded. Then you start to think, well, that chain might not be as resilient as we first thought. The brother could quite easily be mistaken for Mr. Defendant. In a video, he has the same clothing, and he's also on the Verizon family plan and has the same model phone. So obviously then the second chain and the first chain start to be a little bit more challengeable, because if the brother had done it, it's very likely that the same evidence would be left. Now, you add to that something that was also in the discovery, that police surveillance had noticed that the brother's car was parked outside. They noted that it had a stolen license plate on it, which is obviously shows intent to, or a lack of respect for the law, let's say. And so you start to see how a case can be built by focusing on these things and working through these problems and double checking it. Essentially, the role is to shine a light into the areas of a case that are uncertain. Obviously, forensic reports and things are going to focus on their strong case, but there's going to be little areas that you might not have realized, might be uncertain, and you shine a light. Might not, end up being anything, but that's the role, to highlight these unanswered questions and to follow them through to completion. And then, in this case, discovering this brother and what you thought knew, suddenly might be worth challenging, and suddenly, the public defender has a case to argue. What seems like futile exercise becomes something that he can actually, put forward into court and let a judge or jury decide on. So that was a case that, that really, I formulated this chain of suspicion model around, and it served me in good stead since then. But yeah, that's part of the role, the primary role, really, of a forensic examiner working in a criminal defense field, is to understand the case, let the attorneys know what is undecided and challengeable, and help them think about things in a slightly different way, and also help them go through this discovery, because there's a lot of it, and it's hard to wrap your head around, when it delves into technical areas.